Okay, hi guys. So it's about the legal reasoning section, and the first impression which I had when I opened the paper and when I went to the legal reasoning section, I was actually very happy looking at the paper. Why? Because I felt that these are the topics which each one of you have already studied and you actually know all the passages. So if I pick, I just to have a give a quick analysis of the passages. So the first passage in my paper was of illegitimate child. So I had already stated to you guys in the sprint session also that since family law pay clat is focusing, they would be coming and they would be asking this aspect because this is the only thing which is very much in news, which is talking about the inheritance right. Similarly, digital data protection was very much in news, so you were expecting question, and I had told this specifically that this is one topic where you need to focus on. Similarly, freedom of press 19(1)(a), because sedition, defamation, Justice Chandrachud talking openly about the roles of media, and many other judges were talking. So I had told you that freedom of press is one aspect which you can expect. Similarly, defamation was one expected topic. This also I had already mentioned. If I have to say, obviously, juvenile justice act or juvenile justice care thing, although directly I had not stated in my online sessions that you would be getting this passage, but I had mentioned that criminal reformative system, and when we were talking about criminal law, I had mentioned about the aspect and the amendment, and why it is needed, why there is a reformation which they think that that shall be given to the children instead of sending to the normal jail. So every aspect in legal was very much, you guys were very much aware about it, and there was nothing new, and I'm expecting that this is one section where you guys can easily score around 27 to 30. So if someone of you scores 32, that would not be a surprising factor to me. Okay, so now I'll quickly go ahead with the passages and I'll tell you the answers of each and every question. So the first question was obviously talking about, I mean, the first passage on your slide is talking about the uh, PRP bill and why the guild is, criticizing it. Why they are considering it to be a threat to the freedom of press and the other implications of the same. So passage you already know. So I'll directly go to the question. So the first question says, PRP bill defines newspaper to mean a periodical of loose folded sheet, usually printed on newsprint and brought out daily or at least once in a week, containing information on current events, public news, or comments on public news. Who among the following is covered by the definition of newspaper? First, X publishing news content on digital media. This won't come under newspaper because this is not a loose folded sheet. Similarly, book is not a loose folded sheet, so option B also gets eliminated. But if I take into consideration option C, Mr. Z publishing news content in a print media on weekly basis. So here it is already mentioned, or at least once in a week. So if you take this point here, option C would be the right answer. Moving to the next question. Who among the following is not eligible to publish a periodical as per PRP bill? Mr. A convicted of waging war against government of India. Mr. B accused of unlawful activities under the Unlawful Activities Prevention Act. Mr. C accused of terrorist activities under the Unlawful Activities Prevention Act. D, all of the above. So in this case, if I look at the options, a convicted of raising, who among the following is not eligible to publish a periodical as per the PRP bill? A convicted of raising war against government of India. Mr. B accused of unlawful activities. Mr. C accused of terrorist activities, and D is saying all of the above. So here, if you go back to the passage, here it is saying, interestingly, PRP Act had no such provision, given the liberal and arbitrary use of UAPA, which is the basis of defining terrorist as act as an unlawful activity, as well as other criminal laws, including sedition against journalists and all. Guild is deeply concerned by the introduction of these new provisions, as the way can be misused to deny the right to bring out news publication to person who are of critical government. This is mentioned over here, and then sorry, The paragraph before it says the registrar to deny the right to bring out periodical and cancel the certification of registration of a periodical to person convicted of terrorist act or unlawful activity or for having done anything against the security of the state. So all the three options gets covered by this paragraph. So here the right choice will be D, all of the above. Then third question says, which of the following is a threat to the freedom of press in India? Liberal use of unlawful activities prevention act against journalists, refraining journalists from tracing, tracking, and publishing investigate articles because they apprehend that they might be linked with criminals. Use of sedition law against the journalist under the guise that through their articles they are promoting hatred and exciting disaffection towards the against the government. C says levy of GST on newspaper. D say both A and B. So obviously here the right answer would be D, both A and B. Levy of GST on newspaper is nowhere mentioned. And as we had just discussed this passage, this paragraph, which is talking about the sedition aspect, which is talking about the unlawful aspect also. So A and B both are correct over here. So right choice would be D, both A and B. Moving to the next question. The PRP will define specified authority to mean a district magistrate or collector or such other officers as the state government or as the case may be union territory administration may by notification specify. The PRP bill is criticized by Editors Guild of India. Okay, so one aspect in this question was this aspect is focusing on the definition, but the question is asking about why it is being criticized by Guilds of India, because it has nothing to do with the definition aspect. A, the definition of specified authority is too wide and can include even officers below the level of collector. The PRP will enables the specified authority to perform the functions of Press Registrar General. B says the PRP bill confers various power on the Registrar General, including the power to register, deny registration, cancel the registration. The PRP bill enables the specified authority to enter the premises of a periodical for inspection. So here again he is criticizing because of all the three aspect which is there. So if you look at the entire passage, he is worried about the definition, he is worried about the registrar right, he is worried about the liberty and arbitrary use and where it is says that it is misused, it can be misused to deny the right to bring out news. And then he is also talking about the press registrar to enter the premises of periodical. So all the three option A, B, and C are correct. Hence, option D would be the right choice. All of the above. Moving to the next question. Freedom of press is not specifically guaranteed under the Constitution of India but is implied in Article 19(1)(a), that is freedom of speech and expression. Therefore, freedom of press is a part of fundamental rights. So, this is a statement which they have mentioned, and then this is something which is not given in the passage for sure. First option says freedom of press being a fundamental right, no law can be made for registration and denial of registration for newspaper. This is not true. We all know that there can be laws made for fundamental rights as well. B says that fundamental rights are not absolute right and reasonable restrictions can be imposed on the exercise of fundamental rights, and therefore laws such as PRP bill can be enacted. C says freedom of press being a fundamental right, journalist and press is exempted from the operation of general criminal law of the country. This is also not true. Fundamental right does not exempt you. And D says none of the above, which is again not the right choice. Here option B is the right choice, which is based on your common sense, your basic legal knowledge, that fundamental right is not an absolute right and reasonable restrictions can be imposed on your fundamental right. So here option B is the right choice. Moving to the next question. PRP bill denies the right to publish periodicals to a person who has been found to have committed a terrorist act and has been convicted by a competent court in India. Which of the following is most appropriate reasoning? The right to publish a periodical is denied because criminals do not possess any fundamental right, which is a wrong statement in itself. Everybody does have a fundamental right. B, the right to publish a periodical is denied because such a person is threat to the society and nation. C, the right to publish a periodical is denied because they may not be neutral in reporting and may incite violence and spread disaffection against the state, being themselves involved in terrorist act. D, all of the above. D gets overruled. Here, it seems that option C is the most appropriate choice. Why? Because neutral in reporting, this is what is being mentioned over here. The way they can be misused to deny the right to bring out news publications to person who are of who are critical of government. So here, keeping that in mind, I'll go ahead with choice C, which is the right answer. Okay, so moving to the next passage. Next passage is talking about the welfare of juvenile. So the first question is, which is the primary objective of Juvenile Justice Care and Protection Act 2015? To punish, even if I would not have read the passages, I would have marked this answer very correctly. To punish child offender, this is never the purpose of law. To rehabilitate and integrate children in conflict with the law. To remove all forms of violence against children, that is not also the role of Juvenile Justice Care and Protection Act. To increase the age of criminal responsibility, that is also not there. So option B is the right choice. So this is again based on common knowledge also, although it's mentioned in the passage itself. Who makes up the juvenile justice board? Two judges, a metropolitan magistrate, and two lawyers, a metropolitan magistrate or a judicial magistrate of the first class, and two social worker. This is clearly mentioned over here. These board consist of a metropolitan magistrate or judicial magistrate of the first class and two social workers. So keeping that in mind, option C would be the, yeah, one second. Option C would be the right choice. Next question. What is the role of juvenile justice board? Again, I can mark it without reading the passage. To determine the punishment for juvenile offender, this is not the role of the board. To decide whether a child should be sent to a regular prison, this is again not the role. To assess the age and circumstances of the juvenile and make decision on rehabilitation, this is what is the role of the board. Here it is clearly mentioned the primary function of JJB is to determine the age of juvenile, the circumstances in which the offense was committed, and whether they should be sent to special home or released on probation. So this is what is talking about, that they are supposed to make decision on the rehabilitation aspect. So option C is the right choice. Next question. What is the distinction between a child in conflict with law and a child in need of care and protection? Again, this is being mentioned over here itself. The Act makes a clear distinction between a child in conflict with law and child in need of care and protection. A child in conflict with the law is one who has committed an offense, while a child in need of care and protection is a child who is vulnerable or at risk and requires special care and support. So here, if we go back to the option B is the right choice because it's clearly mentioned a child in conflict with law has committed a crime, while a child in need of care and protection is vulnerable or at risk. So keeping that in mind, option B is the right choice. Under what circumstances can children between the age of 16 and 18 be tried as adult? They can always be tried as adult. This is not mentioned in the passage, so A is not the right choice. B, after a preliminary assessment by the board. C, when they have committed any offense regardless of the severity. D, when they reaches the age of 18. So here, if you go back to the passage, it says for children between age of 16 who have committed heinous offenses, they can be tried as adults subject to a preliminary assessment by the board. And this assessment considers child mental and physical capacity to commit such an offense. So here, keeping that in mind, option B would be the right choice, that are after a preliminary assessment by the Juvenile Justice Board. Next question. What is the purpose of placing restrictions on the publication of information related to juvenile offender? To increase the age of criminal responsibility, this is not the right choice. To protect the privacy and future prospect of the child. C says to encourage public shaming of juvenile offender. D says to help law enforcement track juvenile offenders. So as we talk about this Juvenile Justice Care Act, It is designed to ensure children in conflict with law receive special care, protection, treatment with the ultimate goal of their rehabilitation and regeneration in society. You don't want to punish them. And you just the act places restriction on publication of information that could lead to identification, and this is done to protect the privacy and future aspect of the child, because when you are regenerating and rehabilitating, you don't want their past to attach with them. So keeping that in mind, option B would be the right choice. Okay, moving to the third passage. Third passage is talking about defamation. Okay, here the question is, what is the primary focus of the passage? So here passage is divided into two parts. One part they are talking about the liabilities of the intermediaries like social media platform, Facebook, Instagram, YouTube, and on the second aspect they are focusing on the defamation aspect. So, A says the rise of social media in India. This is not what the passage is talking about. B says the legal aspect of online defamation in India. C says the role of intermediaries in online content. D says the importance of freedom of speech on internet. So here, if we look at the entire passage, so either option B or C seems to be the right choice. But why we'll go ahead with option B is because the first paragraph is talking about online defamation. Then last paragraph is also talking about, that what shall be taken into consideration. They are talking about the careful examination of the content, context and intent of the statement. So overall focus is on online defamation, and they're not specifically focusing on the role of intermediaries. So although I went ahead with choice B, some of you may have chosen option C also, but according, so it is one aspect where you may be confused that whether option B and C is correct. So we went ahead with choice B, and some of you, if you have chosen option C, will have to wait for the official confirmation from the consortium. But according to me, option B would be the right choice because the aspect is focusing more on the online defamation rather than the role of intermediaries. Okay. Moving to the next question. What is online defamation as described in the passage? Making harmful statement about someone in person. Obviously, this is not online defamation. False statement made on internet that harms someone's reputation. This is what is mentioned in the passage. That online defamation includes defamatory statement made on the internet, including social media, blogs, forum, and other online platform. So keeping that in mind, option B would be the right choice. Moving to the next question. What is the significance of Section 79 of IT Act as mentioned in the passage? It defines defamation laws in India. No, it does not define defamation laws. It provides safe harbor for intermediaries in case of online defamation. It regulates the content on social media platform. It does not. It allows private complaints against online defamation. It does not. Here it is clearly mentioned. Section 79 of IT Act provides a safe harbor for intermediaries, stating that they are not liable for the third party content if they act as intermediaries and follow due diligence in removing or disabling access to the content once notified. So, keeping that in mind, option B would be the right choice. Okay. The fourth question says, according to the Supreme Court of India, according to the Supreme Court in Shreya Singhal versus Union of India case, under what circumstances should intermediaries act in response to content removal? Upon receiving a private complaint, upon a valid court order or government directive, clearly mentioned, in which the Supreme Court clarified that intermediaries are required to act upon a valid court order or government directive to control removal, not upon private complaint. So, keeping that in mind, option B would be the right choice. How does the Indian legal system balance the right to freedom of expression and the right to reputation in online defamation case? By favoring freedom of expression over reputation, by favoring reputation over freedom of expression, by carefully examining the content, context, and the intent of statement, by absolving intermediaries of their liabilities. So, again, last paragraph is talking about this. Here, the Indian legal system requires a careful examination of content, context, and intent of the statement. So, keeping that in mind, option C would be the right choice. Okay. In an online defamation case, what must the plaintiff prove about the defamatory statement? That it was a political activism? Not at all. It was made with good intentions? Not at all. That it was true and intended to inform the public? Here we are talking about the plaintiff. That means whose rights has been violated. So here, plaintiff in an online defamation case must prove that the statement was false, damaging to their reputation, and made with a degree of fault, such as negligence or actual malice. So, keeping that in mind, option D is the right choice, that it was false, damaging to their reputations, and made with a degree of fault. So, option D is the right choice. Okay. What is the role of intermediaries in context of online defamation case? To actively monitor and censor content, to act upon private complaint. So we just read that this is not the job of intermediaries, so B gets ruled out. To completely absolve themselves of liability, this is also not there. To encourage online defamation, this is not the role of intermediaries. Here the law says, one second, where it is mentioned. Yeah, the court has emphasized that intermediaries should not take a proactive role, but this doesn't mean that they should not take an active role. So, keeping that in mind, A is the right choice, that to actively monitor and censor content, but not proactively monitor. So, option A would be the right choice. Yeah. The next one is talking about the void and voidable marriage, child born out of a voidable marriage. What is the right? What are their inheritance right? Okay. So the first passage question is talking about Ashrama and Ashok got married to each other in a traditional Hindu ceremony in Kolkata, after which they both moved to USA, where Ashok had a job. In the USA, they had a child whom they named Gogol. Many years later, Ashma found that Ashok was already married to Shushma before their wedding in Kolkata. Ashok and Shushma also had a child from their marriage, Arpita, who was older than Gogol by 4 years. Ashok explained to Ashma that although he had no intention of cheating on her, he had to keep his marriage to Shushma a secret, since his parents would have never agreed, as Shushma belonged to a different caste. Ashima is shocked to learn that her marriage to Ashok is void as per Hindu marriage law, since bigamy is not permitted. And since he was already married before their wedding, she is trying to explore possibilities so that Gogol does not lose his inheritance from his father's side of the family. uh, Based on your reading of the passage, what do you think is the correct position with respect to Gogol's inheritance right? He could claim the entirety of Ashok's shares of the ancestral property. He cannot, because there is Arpita also. He would inherit the entire ancestral property as the only son of Ashok. That is also not there. Passage is clearly mentioned कि आप उस property में से father की property share निकालोगे, and then that would be given. So keeping that in mind, B is also not true, and there is Arpita also involved in this thing. C says Gogol would inherit his share from Ashok's share of the full ancestral property without prejudice to the inheritance of other legal heirs, including Arpita. D says only Shushma and Arpita are the rightful legal heir of Ashok. No, since passage is talking about void and voidable marriage, so Gogol is also having right over the property. So keeping that in mind, option C is the right choice. Okay, this is one passage where they had actually asked fact-based questions. Second says, in the above fact scenario, consider a property that was purchased by Ashok from his own earning in USA, thereby not making it as a part of ancestral property, but instead falling in the category of self-acquired property. Upon Ashok's death, who would have inheritance right over the said property? So Shmita, Shushma or Ashima? Since Ashima is The marriage between Ashok and Ashrama is void. She would not be inheriting. So wherever Ashrama is the option, it will get ruled out. So A gets ruled out, B gets ruled out, D will obviously get gets ruled out because Gogol is also having right over the property. So keeping that in mind, option C is the right choice. Based on your reading of the passage, how did the Hindu Marriage Act influence the outcome of the case on inheritance? Select one option from below. The amendment provision of the Hindu Marriage Act grant legitimacy to children from voidable marriage, and therefore this logic should be extended to children born of voidable and void marriage under Hindu Succession Act. The amended provision of the Hindu Marriage Act gives legitimacy to second marriage, and therefore this should have second marriage को legitimacy ही नहीं मिलती, तो B तो ruled out हो गया. The amended provision of the Hindu Marriage Act grant legitimate status to children from void or voidable marriage, and therefore this should also extend to Hindu Succession Act. D says the Hindu Marriage Act has no bearing on the case in question. D gets overruled. Now we are supposed to decide between option B, A, and C. Option A is just saying that it grants legitimacy to children from voidable marriage. No, it grants the legitimacy to children from void and voidable marriage. So, wahan pe, since void is missing, option A will get ruled out. So, we will go ahead with choice C, which is the right answer. Option C is the right choice. Okay. 12-year-old Kaushalya was married off to 23-year-old Dashrath in her maternal home in Uttar Pradesh. She completed her education after her marriage and went on to get a job as a teacher at a government school. Dashrath's family, however, was opposed to her taking up a job outside the house and insisted that she should stay at home and look after her two sons, Ram and Lakshman. Kaushalya, however, was very excited about starting her new job, and she sought advice from her younger sister, Varshini, who was training to be a lawyer. Varshini advised her that since she was married before she turned 18, her marriage was voidable and she could get it annulled. So now the children are born out of voidable marriage. Kaushalya, who was not very happy in her marriage, considered this option but is worried that her son may lose their inheritance. Select the option that denotes correctly the status of Ram and Lakshman. So, since Ram and Lakshman are now born out of a voidable marriage, they do have a right to inherit the property. So, A says cannot inherit, which is a wrong choice. B says can inherit their father's shares of the ancestral property, irrespective of the voidable status of their parents' marriage. C says if she decides to annul her voidable marriage, she and her son would lose all right of inheriting. This is not true. D says they can only inherit ancestral property from their mother's side since she decided to annul the voidable marriage. This is also not true. So, living by the elimination rule, we can choose option B, which is the right choice. That this, since they are born out of voidable marriage, they do have a right to inherit the property and share of his father's in the ancestral property. So, keeping that in mind, option B would be the right choice. Okay. Ajay is married to two women, Dia and Ria, and both don't know of each other. He was married to Dia first, so that's a valid marriage. When they were both around 23 years of age and studying together in college, they have no children. He later got married to Ria in a temple, and she had no idea about the first marriage with Dia. So, marriage with Ria is a void marriage. Ajay and Ria have two children, Raj and Rani. One day, Ria found out about Dia from one of Ajay's college friends. She wants to divorce Ajay but finds out that her marriage to him is void since he was already married at that time. At a loss, she goes to a lawyer to find out about the rights of her children in inheriting the property, which is the most legally sound advice that the lawyer could give it to her. He would say that her children can still inherit property from Ajay thanks to the Supreme Court judgment. B. He should advise her to get her marriage registered so that they can inherit property. How can the marriage be registered when this is a void marriage? So B gets ruled out. He would advise her to ignore her marriage with Ajay since it is anyway a void marriage, not a sound advice because children's ke right concern hai. He would get advice her to speak to Dia and sort it out with her so that her children can inherit property since this she would have the final say. That is also not true. Keeping in mind the Supreme Court judgment where they have stated child born of a void or voidable marriage can inherit the property, option A is the right choice. Moving to the next question. In the above scenario, Ria wants to know if there is any way in which the judgment can come to her aid while inheriting property owned by Ajay. What would be the correct position? No, she cannot inherit property as a judgment merely talks about the right of children from void marriage. Yes, she should fight for her rights. She cannot fight because it's a void marriage. Ajay would have to give her property since he cheated on her. Passes is nowhere talking about this, so she gets ruled out. She should get an equal share of property as Dia, since they both are his wife. No, one is not a legally wedded wife as per the law. It's a void marriage. So keeping that in mind, option A is the only left out choice. So A is the right answer. Last question. Srimati's first marriage was void due to being within the prohibited degree of relationship. Dhanna Lakshmi, who is the daughter of Srimati from her first marriage, confronts her mother once she finds her identity, demanding her share in mother's ancestral property. Srimati, however, subsequently married Drupad and has two daughters with him, Ira and Shira, and is not interested in giving any property to Dhanlakshmi. Dhanlakshmi decides to assert her right in a court of law. How would Dhanlakshmi share be determined? She would not have any right in her mother's share of the property since the right of inheritance pertain only to father's share of property. No, if you read the passage, it is talking about parents' right to their parents' property. So that includes mother and father as well. So A gets ruled out. B. Dhanlakshmi could demand a national partition and get a share from Srimati's portion for her of her ancestral property. C. Being a child from a void marriage has no right of inheritance gets ruled out after the judgment. It is Srimati's decision as to whom she gets rights in her property. That is also not true. So keeping again here by elimination rule also you can go ahead with choice B, which is the right answer. Okay, now I think we are left with the last passage, which is talking about Digital Personal Data Protection Act. And this is talking about when the data can be used, what are the exemption which is given to the government. So Mr. Lal was suffering from a rare disease and data relating of that was collected by the government. Suppose the DPDPA 2023 provides exemption for the government relating to data deemed necessary for research, archiving, or statistical purposes if the personal data is not to be used to take any decision specific to a data principle and such processing is carried on in accordance with such standard as may be prescribed. Which of the following is the most appropriate answer? The personal data of Mr. Lal can be preserved by the government till the research on rare diseases complete. The data can only be used for taking any decision. One second. Yeah, the data can be used only for taking any decision regarding Mr. Lal. C says the personal data of Mr. Lal health condition and his personal data can be preserved by the private hospital, which is not correct. Just give me a second. Option D is missing in this passage. One second. I mean, in this slide, it is missing. Yeah, option D says all of the above. So here the right answer would be that the personal data of Mr. Lal can be preserved by the government till the research on rare disease is complete. If the personal data needs not to be used to take any decision specific to data. So the question itself is suggesting कि जब तक research है government use कर सकती है उसके बाद the government need not to or as per the standard or as per the requirement they can keep the data or they cannot keep the data. So keeping that in mind, option A is the right choice. Yeah. Suppose the DPDPA provided exemption for the processing of personal data for the purpose of ascertaining the financial position of any person who has defaulted in payment of amount due to loan taken from nationalized bank. Now, Mr. X commits a default in prepayment of EMI of loan taken from a nationalized bank. The bank can demand access and process the personal data of Mr. X relating to family history of ailment, nowhere mentioned in the passage, so this gets ruled out. The bank can process the personal data of Mr. X with the particulars of the family, wife, children, brother. That is also not needed, so they cannot do so. And then it is clearly mentioned in the question provided exemption for processing of personal data for the purpose of ascertaining the financial position of person who has defaulted. So आप सिर्फ defaulted का data लोगे आप पूरी family history नहीं लोगे. So A and B gets ruled out. C is the right choice, that the bank can process the data of Mr. X for the purpose of ascertaining the assets and liabilities of the defaulter. Suppose Mr. Y, a citizen of India, is working in an MNC in New Zealand since 2021. The MNC has obtained personal details of employee for the purpose of recovering the amount of indemnity bond if Mr. Y left the job within 3 years of joining. A can file an application in India for protection of his digital personal data if he leaves the job in September and returns to India. This is nowhere mentioned in the passage कि वो कब छोड़ के इंडिया वापस आके कर सकता है नहीं. So A gets ruled out. Mr. Y, being a citizen of India, can claim protection against MNC for misuse of his personal data even while serving in New Zealand. He cannot do so. Y will come to the next option. The DPDPA is not applicable since the data is held outside India. This is clearly mentioned in the passage itself. The law exempts processing of personal data held outside of India. So, keeping that in mind, option C would be the right choice. Okay, D is something which we will not go ahead with because passes kahin pe bhi retrospective application ke baare mein is not talking. So, D is not the right choice. So, option C is the right choice. Okay, if personal data is defined as any data about an individual who is identifiable by or in relation to such data, which of the following shall be classified? So, you can identify a person by his name, you can identify a person by his residential address, you can identify a person by his Aadhaar number also. So, keeping that in mind, option D is the right choice, all of the above. Fifth one, in which of the following cases the access to personal data shall be granted and the person whose data is accessed and processed cannot claim personal data protection? A has committed many robberies and police wants to access his Aadhaar details. Okay. It is B says it is apprehended that the person identifies as Mr. G would spread hatred among various communities, which would lead to riots, and police intend to use the mobile number and personal details of Mr. G for the purpose of preventing such crime. So here it is clearly mentioned. Okay. Security agency will have significant authority to collect and retain any data whatsoever, as typically the case with exemption relating to the maintenance of sovereignty, integrity, and all is mentioned over here. Preservation of public order, prevention of offenses, incitement to criminal offenses. So, sorry, incitement to commit offenses. So, keeping that in mind, we'll go ahead with choice C, which says both A and B. Okay, somewhere it's also mentioned now. Okay, one sec here. Yeah, this same paragraph is talking about this. So keeping that in mind, both A and B would be the right choice. Okay, which of the following is correct? Personal data collected by a health service provider can be sold to an insurance agency. They can't sell it, so A gets ruled out. Personal data collected by the government can be used for whatever purpose. C says the personal data collected by the insurance company can be sold to mobile companies. Not true, so C gets ruled out. Since A and C gets ruled out, D also gets ruled out. And here it is mentioned the government is not bound by purpose limitation allowing data collected for one specified purpose be used for a new incompatible purposes. So keeping that in mind, option B would be the right choice. Okay, so this is all about legal section, guys. Now you all know the answers of each and every questions. You can map, you can also go to the score calculator and put up your score to get an exact idea of what is your score. Okay, so this is all from us. Thank you so much. And now don't worry about the result, cutoffs, and everything. Please go take some rest today. And from tomorrow onwards, start focusing on your NLUD exam, which is scheduled for next Sunday. Thank you so much, guys. You can visit to lawentrance.com/clat for your score calculator. Thank you so much.